This is Dr. David Shine, and welcome to Business Law 101. Obviously, the whole purpose of having a contract is to get the benefit of the contract or its performance. So we're going to look at some various issues as to how you satisfy the contract or close it out. One of the interesting examples here, I don't follow sports anymore. I work too many hours, but this was a holdout, and the question was whether the person as a rookie can make, has a standard NFL contract, despite his stellar performance, stayed away from off-season workouts, holding out for a new contract, but it won't make a difference. And so this is a pretty interesting deal, is whether he had any legal liability. And the answer is that it's his own shortfall. If he doesn't want to get the money that the NFL has promised him, that's okay. He just doesn't have to show up for work. Now, one of the important terms here, this two in bold print on this slide, is construction and interpretation. Construction is the way the contract's words are written. And of course, this is the lawyer's stock and trade. Interpretation is what juries and judges do, which is to understand the intent of the words that are written. Now, keep in mind that there are conditions that often surround contracts. So we're going to look at this. There are three levels of timing in conditions. Condition precedent, good example of this is you go out and you go to a dealership, you see a used car, and you say, I want that used car, but let me tell you something, those tires are pretty shabby looking. So I will buy that car for the current price, but you've got to put a new set of rubber on the tires for me, and something like that. So that's a condition precedent. I'm not obligated to buy the vehicle until it has new tires. Condition concurrently. This is a COD, cash on delivery. I bring you the merchandise, you make the payment, COD, condition concurrently. Condition subsequent is something you're required to do after the contract is in place, and it creates an obligation for the performance to become absolute. Now, what we want, again, as business people is express conditions. We want them written plainly in the agreement. Constructive conditions are things that the parties missed but are implied from the contract and the court will enforce. That's a rough way to go, and you could spend a lot of money over at the courthouse. Now, one of the things that we see that again causes a lot of disruption is when we put in a subjective standard, like we want you to paint our house and our standard will be we're happy and then you can stop working and we'll pay you. Well, that type of subjective evaluation of a paint job could be an extreme responsibility and could be a very difficult situation. Now, objective dissatisfaction in many cases, like a construction contract, may involve a third party like the city inspector or a special inspection service coming out and saying, we will not be obligated to pay for the new plumbing system until an independent third party comes to us with the way this thing is supposed to be. So you may say, I'm getting some air conditioners and the air conditioners are inspected by the city. If the air conditioners are rejected a couple times by the city, your obligation has still, excuse me, has still not occurred. You're still not obligated until the situation is clarified and it's established that what you need is what has already been accomplished. And through a third party like a city inspector saying the plumbing is now suitable. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.